Good day, Crime Talk aficionados. We have a huge show for you today. First, should Bryan Kohberger not be able to be sentenced to death because he has autism? Oh, and by the way, whose DNA was under Madison Mogen's fingernail? Former Sheriff Mickey Stein is going with an insanity defense. A solution to the problem usually does not involve killing the witness against you. An execution will take place in South Carolina with a firing squad. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the docket today, and it is a big one, and I'll tell you why in just a second, this is why you need to go to CrimeTalkSearch.com. For all of our true crime aficionados, you want to dig deep, do you not? Well, one of the ways you can do that is to go to CrimeTalkSearch.com. You can search the people that are witnesses, and you can get a background search literally prepared while you wait. Now, obviously, you don't want to do anything negative with that, but for your information, you may want to check somebody out, just like somebody coming into your life, or maybe someone you're not sure should continue to stay in your life. You can check them out by getting a background subscription service to be able to run those background searches. And the result is literally prepared to and sent to you while you wait. When you get that report, it's going to have all types of information, somebody's background on their presence on social media. It's going to have information regarding whether they have liens, judgments, criminal history. Are they on one of those registries that you hear so much about? Go to CrimeTalkSearch.com. You're going to be happy you did. Before we get to today's docket, we didn't go live last night, had some other commitments that I had to take care of, so I apologize in advance for that. We'll see how the schedule goes. We'll see if there's some breaking news here in the future this week. If not, we'll definitely do it next week. But let's get to the docket for Wednesday, March 5th, 2025. Now, remember the other day we told you about Judge Hippler saying, enough is enough of everything being filed under seal in the Bryan Kohberger case. I totally agree with the court's rationale. Nothing is so sensitive under the rules that it needs to be kept in secret. And additionally, a lot of this information is going to come out at trial. So why are we playing these games of somehow keeping everything secret? Well, what has that done? Well, we got to be able to see the motions that have been filed. And what motions do you say, Scott? Well, motions in limine. Motions in limine are motions filed by both sides saying, hey, Your Honor, we want you to rule pre-trial whether this information, more than likely it's admissible, but we think it may be prejudicial. And so don't allow it in. Well, both sides have got a stack of motions. So I'm going to go over an overview, and then we'll go through in greater detail these motions because it provides a lot of insight where the case is headed. And once again, ladies and gentlemen, like I told you, you file motions, something out if you are the defense. And there's a lot the defense wants to keep out. Now, for those who don't know, back in November of 2022, 4 University of Idaho students were found dead, killed, stabbed to death in their off-campus home in Moscow, Idaho. Now, roughly 9 miles away in Pullman, Washington, guess who happened to live there? Bryan Kohberger. He was a student enrolled there at the university in a PhD program. Now, the students, Madison Mogen, Kayla Gonzalez, Zaina Kernodle, and Ethan Chapin were all obviously deceased. And guess what? Bryan Kohberger has been accused of those 4 murders as well as the burglary, and he faces the death penalty. Now, Bryan Kohberger's attorneys have tried and thus far failed to get the death penalty taken off the table on grounds that it is unconstitutional, that it somehow does not comport with evolving standards of decency, and that it is applied arbitrarily. All things that the Supreme Court says you can't have if you're going to have the death penalty. So in their most recent attempt, they are now trying to say Bryan Kohberger, if convicted, and we'll give him the presumption of innocence, but if convicted, capital punishment should not be imposed because he suffers from autism. Let me explain, ladies and gentlemen. Some people may say, oh, he's got autism. He's probably super hyper-focused. We know lots of people that have reportedly have autism, and they're very high-functioning individuals, but yet they're maybe a little socially awkward. There's some people that could be non-functioning. Clearly, that's not the case because Bryan Kohberger was in a PhD program. This is something that the defense will ultimately bring up in mitigation if there is a conviction. In the sentencing phase, it is mitigation. And there's actually a motion where they say, hey, we don't want the prosecution to flip the script on us because this is our mitigation and you can't use it as an aggravator. All right. We'll talk about that in a minute as well. But needless to say, these attorneys are doing what they're supposed to do. This is good lawyering. And we, as a community, as a society, should expect nothing less for anyone charged with obviously a heinous crime where they're facing the death penalty. They should get excellent representation. And then obviously if there's a conviction, there's less likelihood that the matter will be reversed on appeal if they have effective and competent counsel. Clearly, Mr. Kohberger has very effective and competent counsel. You may not like some of the motions that are being done. You may not like some of their tactics, but they are doing what the defense attorney is supposed to do, hold the government to their burden of proof, challenge the evidence that the government intends to bring forward, and that's where we are today. So like I said, in Mr. Kohberger's latest attempt to avoid the death penalty, his attorneys have filed a motion asking the court to note that he has autism and that it exposes him to an unacceptable risk that he will be wrongfully convicted of murder and sentenced to death. Now, this 28-page motion was unsealed. And like I said, because the judge is allowing everything to be unsealed now. And they're saying that if he is found guilty, it would violate his Eighth Amendment right to remain free from excessive punishment because his autism spectrum disorder diagnosis. Now, he also faces one count of felony burglary. And in this case, the defense notes where jurors will be forced to determine whether Mr. Kohberger will live or die. Mr. Kohberger himself is essentially a piece of evidence to be examined and evaluated. Every movement and expression is subject to an analysis. His attorneys wrote. And they say that Mr. Kohberger, who is studying criminology at Washington State University, is expected to stand trial this summer, and the prosecution tends to seek the death penalty if he's convicted. All right, we know that, but that's in the pleadings. Now, Mr. Kohberger's autism spectrum disorder prevents him from being sentenced to death in a manner that accords with the constitutionality requirements of proportionality and reliability, his attorneys argue. Apparently, Mr. Kohberger's disorder has a significant impact on his life, according to a comprehensive neurological evaluation conducted by Rachel Orr, a New Hampshire-based neuropsychologist. Now, the autism spectrum disorder is a developmental disability that is caused by a difference in the brain, according to the good doctor. And people with autism tend to have problems with social communication, interaction, and restricted or repetitive behaviors. Now, the filing also notes that the core diagnostic feature of autism, such as lifelong issues interacting with people, and this includes the diminished ability to understand people's reactions and difficulty identifying the emotional or mental state of others and how to respond appropriately. Basically, what they're saying is the person can't read the room. Now, while autism isn't an intellectual disability, though some people have both, the attorneys argue that some people with the disability share similarities, especially in regards to prior court findings over the elimination of the death penalty. They argue that back in 2002, the United States Supreme Court ruled that executing people with intellectual disability violates the Eighth Amendment. That hasn't included neurological disabilities such as autism, but as they argue, well, it should. And that sentencing people with autism spectrum disorder to death is also a violation of their constitutional rights. His attorneys also noted that sentencing people with intellectual disabilities creates an unacceptable risk of wrongful execution because the defendants aren't able to help in the mitigation part of their case. Now, you may remember, this is going back to people that involved special needs. They used to use the R word for that. You know, very low functioning. Makes sense. Probably shouldn't kill people that are low functioning. no matter how heinous the offense that they have been convicted of. Anyway, specifically, the court found that the defendants couldn't meaningfully assist their attorneys. Their demeanor might give unwarranted impression that they lack remorse and that they are typically poor witnesses. They go on, specifically saying Mr. Kohberger, that he displays, listen to this, that he displays extremely rigid thinking, lingers on specific topics, processes information on a piecemeal basis, and struggles to plan ahead, which affects their attorney-client relationship and their ability to prepare for trial. He also demonstrates little insight into his own behavior and emotions, she adds, which basically means they're having difficulty dealing with him processing some of the information. Now, it doesn't rise to a level of competency, but once again, it just kind of goes to show that he may function a little bit differently than others, and he may not appreciate the severity of what may have allegedly taken place at his hands. So, no matter how helpful Mr. Kohberger may wish to be, it is simply not possible for him to aid counsel in a way that someone without the deficits accompanying autism spectrum disorder would be able to. Now, the neuropsychologist, Dr. Orr, said that his tone and cadence are abnormal, his interactions lack fluidity, and his language is often over-inclusive, disorganized, highly repetitive, and oddly formal. He's easily distracted by sounds or activity, often needs questions repeated, and uses abrupt, matter-of-fact phrases that could be considered rude. He also has exhibited compulsions around hand washing and other cleaning behaviors. Since childhood, these symptoms of Mr. Kohberger's autism spectrum disorder will alienate him from the jury and significantly hamper his ability to make a persuasive showing of innocence or of mitigation. The filing also pointed out two of the states, Ohio and Kentucky, bar people with serious mental illnesses from being sentenced to death, but autism, well, that's not included in those jurisdictions. Those states specifically say that schizophrenia, schizoaffective disorder, bipolar disorder, and delusional disorder are possible exemptions to the death penalty. Now, Ms. Taylor is concerned that there is a substantial risk that Kohberger's demeanor, because of his autism diagnosis, will create an unwarranted impression of a lack of remorse. People with autism often emerge in repetitive self-stimulating behaviors such as hand flapping, finger snapping, and body rocking. A juror seeing the defendant engage in any one of these behaviors while sitting at counsel table during the murder trial would perceive the defendant as strange, out of control, and even disrespectful of such solemn proceedings. She added that the subtle indicators of autism could be just and damning for capital defendants, if not more so. An inability to make eye contact could be interpreted as guilt or shame, while facial expressions, contrary to the tone of the proceedings, could be seen as cold or lacking remorse. Now, Mr. Kohberger specifically subtly rocks his upper torso when listening to someone, has limited facial expressions, and exhibits atypical eye contact, such as an intense gaze, which the neuropsychologist observed during her evaluations, according to the pleadings. Now, while a lack of facial expression or abnormal eye contact are indicative of autism, Taylor said that to hundreds of thousands of online commentators who developed a cottage industry devoted to analyzing her client's every movement, these symptoms are sure signs of guilt. These widely viewed and highly prejudicial media reports, draped in the language of expertise and analysis, demonize Mr. Kohberger for his disability in an environment such that it is tainted by rampant and vitriolic conjecture. It is impossible for Mr. Kohberger to receive individualized sentencing determinations, including full and careful consideration of mitigation evidence that the Constitution demands whenever the state seeks to extinguish a human life. Now, Mr. Kohberger can't conduct himself in a manner that aligns with societal expectations of normalcy. Ms. Taylor goes on to say that there is an unconscionable risk he'll be executed because of his disability rather than his culpability. Ms. Taylor added that Mr. Kohberger's facial expressions have already been given a sinister meaning in the decision to transfer Mr. Kohberger's case over there to Ada County. They acknowledged that the extraordinary media attention of this case obviously played a factor. She pointed to various news articles that reported on allegations that Kohberger made creepy comments to staff at a brewery in Pennsylvania, made female students at Washington State feel uncomfortable, and lost his job as a teaching assistant for failing to meet normal professional behavior. Given his difficulty interpreting social cues, these allegations could be explained by his autism. The defense is arguing, adding that it was no surprise he came across as socially awkward or struggled to adapt to professional norms. She called his behavior hallmarks of his disability. There is no need to speculate about what impact Mr. Kohberger's autism spectrum disorder might have on his disability to present a meaningful defense, they argued. This is interesting. Oftentimes, you don't get the perfect defendant at the table. I would think that if I was the defense attorney for Mr. Kohberger, that I would say, Judge, I want to be able to bring this up in voir dire and kind of give a general explanation that he suffers from autism, and these are some of the things. So don't read too much into it. I would think the judge would possibly allow that. But to be able to say, let's take it off the death penalty, this judge is going to deny this motion. But it's good lawyering, all right? And it's good mitigation for the penalty phase if he is ultimately convicted. So something to think about. Now, next on the Bryan Kohberger matter, what the heck is going on with this DNA? Whose DNA was under Madison Mogen's fingernail? Well, let's talk about it. So some more pleadings in the Kohberger case have revealed that DNA from 3 individuals was found under the victim's fingernails of murder victim Madison Mogen. Now, in this document that was unsealed yesterday, the accused quadruple killer's defense team reveals that testing of Mogen's left fingernail clippings unearthed DNA evidence from 3 unknown individuals. Parts of the documents have been redacted, meaning the fingernails tested remain somewhat unclear. However, the defense indicates that the comparison to Kohberger's DNA was inconclusive and that he could neither be confirmed or eliminated as a possible source. However, this is the first time it has emerged that there could be additional DNA evidence from the crime scene beyond the leather knife sheath, as well as the blood drop on the railing and the glove outside. Now, a critical part of the case against Mr. Kohberger comes from a brown leather knife sheath found close to Madison Mogen's body at the scene. That's right. The only channel that has their own K-bar, still has a K-bar, didn't lose the knife with the sheath. And I've had this since 1988, ladies and gentlemen, when I was a young lad getting out of boot camp. Anyway, so according to the prosecution, this touch DNA found on the sheath belongs to Kohberger, and that was obviously used to trace him using the investigative genetic genealogy, which we've talked about several times on this show. Now, the defense is asking the judge to limit testimony about the DNA analysis of Mogen's fingernail scrapings, claiming it would violate Kohberger's right to a fair trial. Now, during grand jury proceedings, the court heard testimony that a 3-person mixture had been found on Madison Mogen's fingernail clippings. The data from that sample was redacted as to Mr. Kohberger, the document states, and the statistical likelihood that Kohberger is one of the 3 individuals whose DNA were found on the clipping is also redacted. Now, the filing details the witnesses testified about the meaning of the term inconclusive. Kohberger's defense team is arguing that the testimony used misleading language, and what they should have been talking about was likelihood ratios, which are different from traditional statistics that court and juries are used to seeing at the hearing. The likelihood ratio is a comparison of hypothesis. It's not a statement of identity or probability of identity. It simply asks the question, given the data, which hypothesis tested is more likely? Statistically, it was assumed that Mogen was one of the 3 individuals. So then 2 hypotheses were then tested, and the 3 people included Mogen, Gonsalves, and 1 unknown, unrelated person to Mogen and 2 unrelated persons. Kohberger's defense argues that at least 4 other unnamed individuals were also tested and that they, like Kohberger, also came back inconclusive. All of these individuals sit in the same shoes as Mr. Kohberger, namely that the likelihood ratio is exclusionary but falls in the range of inconclusive. His defense argues that focusing on Kohberger's DNA being inconclusive would be misleading at the trial. Let me give you a little explanation. Now, I had an expert try to explain this to me. All right. in simple terms. And this is from way back. All right. And it says, hey, the statistic used of likelihood ratios is increasingly popular statistic called a likelihood ratio. This is a very different statistic. That is what people used in criminal cases. A likelihood ratio is not a direct measure of whether DNA on an item of evidence actually came from the defendant or not. Instead, it measures the relative strength of one assumption, typically that the DNA comes from the defendant, versus an alternative assumption, typically that the DNA comes from just some random person picked off the street. So the statistics, it's all about theories and assumption. The statistic test does not require that either of the theories actually be true. Also, the statistic is strictly about the likelihood of the DNA profile on the evidence. It is not the likelihood of who the DNA came from. Thus, it is not correct to say that it is, say, for example, 2 times more likely that the DNA on the item is from the defendant. To do so commits a logical fallacy and is very misleading. So if you also hear that there is the laboratory comes up with there is a limited support for a particular theory that the DNA came from a particular person, that's good. In fact, it's on the very edge of providing any support at all. And the likelihood ratio obtained in a case, if it's so low, is near the point where the lab would have to flip their interpretation and report that the evidence better fits the alternative theory / assumption. So if the likelihood ratio were less than 1, the lab would say the alternative theory has limited support. So, and this has always been my problem with a lot of the DNA stuff, was that the odds of it being some random person, someone other than the defendant, are 1 in 760 quadrillion, right? And how many zeros is that, Miss Expert? So they're playing game. It's lots of theory and it's lots of statistical analysis. But guess what? I'm sure the defense has their people. They say, you can't say the likelihood ratio that it came from Mr. Kohberger because it was such a small sample. But guess what? The prosecution will be able to say, we found this information. It goes to the thoroughness of their investigation. And more than likely, they will say that it was inconclusive as to Mr. Kohberger under Madison Mogen's fingernail. And then certainly the defense can conduct cross-examination of their witness, the prosecution witness, or in the alternative, they can bring in their own expert to explain what's taking place. Anyway, the defense says, hey, this is super prejudicial to Mr. Kohberger, that it's going to say, hey, there's a theory that could be his DNA, but we can't say conclusively that it is. But it goes to their investigation. Certainly the defense will be attacking their investigation. And if they didn't bring that up, they'd say, oh, you didn't bring that up because that shows something else, right? They're going to be able to explain it to the jury. So nice try, but it is coming in my prediction as it relates to this particular motion. Like I said, the judge is going to say it's coming in, and you can certainly cross-examine it, the witness on this information, but it's coming in. Anyway, the legal team for Bryan Kohberger argues that the additional testing since the defense carried it out has now actually excluded Bryan Kohberger as the source of that DNA, which I'm sure they will have their expert lined up and ready to go. And if that's the case, that's what trials are for, right? Questions of fact. Anyway, these new details about the DNA evidence was revealed, obviously, in all of these motions that we obviously would not have got, but for Judge Hippler saying enough is enough. So let's go through these motions, because we got the bushy eyebrow motion, we got the psychopath motion, the sociopath motion, as well as some other good stuff like, hey, you can't use the word murder weapon, denied. Anyway, let's do that. Now, first, there were a couple of orders by the judge. One, ordering the parties a stipulated agreement regarding investigators in the courtroom during trial. That's pretty standard. Why, you say? Because, well, everybody's entitled to a witness. There's going to be a lot of moving parts. Let them have their investigators in there. So we just talked about motion to extend, one of the motions filed by the defense was motion to extend the time to disclose defendant's guilt phase experts, and basically saying, hey, we need additional time because the prosecution has not turned over that information in a timely fashion as it relates to their experts. Reply to the state's objection to defendant's motion to compel material and motion for sanctions. Once again, discovery type issues, not a big deal. And they say, hey, listen, we've been doing everything we can to provide discovery. There is 68 terabytes of information in this particular case. We're trying to do it the best we can. Therefore, Mr. Kohberger must be able to confront the evidence against him, and to do so, it must be disclosed in accordance with the rules. This is always good. Motion to exclude inflammatory evidence. That's like saying, Judge, I would like to exclude this evidence because it is prejudicial to my client and it is killing our defense. That's right. It happens. So what does the defense want to exclude? That's right. Prejudicial information. Always go to the conclusion. Mr. Kohberger's right to a fair trial from free, irrelevant, cumulative, and unfairly prejudicial evidence, as guaranteed by the Constitution of the state of Idaho and the United States of America, would be violated to allow exhibits depicting gruesome details of the emotional reactions of police officers at the scene during their testimony at trial. So, all the body-worn camera where people are getting emotional, autopsy photos, there's hundreds of photographs of the crime scene, body-worn pictures of officers moving throughout the house, hundreds of hours of photography of autopsy proceedings, and basically saying it's not going to come in. It's not all going to come in. First of all, it has to be relevant. It has to be not extremely prejudicial under Rule 403, that its probative value is, that its prejudicial value is outweighed by its probative value. And so what happens is normally you get the crime scene, you get the back up, you get the medium, and then the close in. You get the autopsy. They're usually going to be blacked out for the faces and things of that nature. The jury will get to see them. It's a freaking homicide case where people died by stab wounds. Now, do they need to see thousands of photographs? No. Prosecution's probably going to be told, pick your best 50, so to speak, and you can do that. And that's normally what the judges do. They're like, well, we don't want to give them too much, but we got to give them something that shows what the heck actually went on. So that'll be granted in part and denied in part, where the judges say, well, they're going to get to be able to show some things, and I'm sure you're not going to like any of it. But if it starts to become cumulative, and it's so out there, I won't let it in. But that's a evidence by evidence ruling that the court's going to have to make. Motion in limine, vague and undisclosed expert testimony. They want to exclude, the defense wants to exclude forensic testimony of Jenny Ayers. And it should be limited to her work only depicted in the state of Idaho Forensic Laboratory, and any other testimony outside of the testimony of her testimony from those reports should not come in. They want to exclude the testimony in portions of Special Agent Nicholas Balance. Testimony must be prohibited as no report containing findings or opinions has been produced. The only disclosures are 2 PowerPoint presentations. One is noted as a draft. The PowerPoint depicts information derived from cell phone tower data, call detail records, drive test data, and interpretations of the same. It's clear that in creating this PowerPoint, Special Agent Balance used an unknown methodology to analyze and visualize certain data contained within the defendant's call detail records while omitting and ignoring other relevant evidence. That's coming in, and it can be subject to cross-examination. They would like to limit the testimony of Mr. and Mrs. Barnhart. Testimony must exclude everything other than specifically disclosed, including purported habit evidence. The state has not produced a report specifying what habits or reference to. No expert opinion has been disclosed. Mr. Kohberger can't prepare, and testimony must be prohibited pursuant to the rules. They want to exclude the testimony of Mr. Cox from Amazon. They're saying his testimony must be excluded because no opinion or full analysis of the data has been provided. It appears that he has credentials to gather data at Amazon, but nothing disclosed indicates he has the expertise to form an opinion on data, and if he does have an opinion based on the analysis of that particular data. I want to exclude the testimony of a Michael Douglas because his testimony should be excluded, they argue, and all arguments set forth in Shane Cox in paragraph 4 are incorporated for Michael Douglas as it relates to the testimony about Amazon and Amazon clicks. Basically saying, hey, you can't really trust these Amazon clicks. It's artificially generated, and he had a shared account with his parents. My guess is, What is he buying or looking at? A little bit of camping gear and a K-bar. We'll go into that in a minute as well. They want various state lab experts who are going to participate at trial to limit their opinions to the reports authored by them and based upon their own expert evaluation. Seems reasonable. Rylene Nolan has been disclosed. A challenge to her proposed testimony is covered in a separate motion, number 6. Eric Seat, the expert testimony of his DNA technician, provides an explanation of possible testimony regarding methodology of DNA testing. They want to keep out witnesses Mowry, Tenzola, and Urig. The state provide no disclosure of expert related to 67 electronic devices and third-party data collected during the investigation. Failed to identify what portions of the electronic device, digital data, or third-party search warrant returns will be presented. They don't want Detective Gilbertson to testify. They say they didn't disclose Detective Gilbertson in their initial disclosure, but instead intend to call him as a rebuttal witness. You don't even have to endorse rebuttal witnesses. Anyway, they say they didn't identify a specific expert or opinion that the detective will rebut. Thus, the court should exclude his testimony. They want to exclude Gary Dawson. This expert was disclosed for the first time in the state's rebuttal experts. He is a toxicology expert. Mr. Kohberger did not disclose any experts relating to toxicology, and this expert is not a rebuttal expert and should be excluded from trial. David Middleman, the expert, was disclosed as a rebuttal expert relating to IgG matters. This expert is addressed in a separate motion. And anyway, keep all these people out. Next one, don't use the term psychopath or sociopath. They say that they want a motion to seek to bar the use of the term psychopath or sociopath. And they say it's under Rule 403, 701, 704, violates the 5th, 6th, and 14th Amendment. Anyway, it says Rule 403 excludes evidence as unfairly prejudicial. They just say don't use that word. Doesn't say why they want to exclude that word. Inconclusive data, motion number 5. This relates to the DNA evidence. All right, let's just quickly go through this. All right. Statement of fact. In a grand jury testimony, Jade Miller testified as to the results of testing done on items Q13.1. A swab of the left fingernail clipping from Madison Mogen. The data consisted of 3-person mixture. That statistic. The likelihood ratio was calculated assuming that Madison Mogen, was a contributor to her own fingernail. Miller testified as follows, and then it's redacted. The data from that sample was redacted. As to Mr. Kohberger, grand jury transcript at 365 and 366. Miller testified that inconclusive means that an analysis is redacted once again. Miller went on to explain that the likelihood ratio for Mr. Kohberger, redacted. They say this is misleading information, and they say that they go on that the likelihood ratio is a comparison of hypothesis, just like we explained earlier. It's not a statement as to identity or the probability of identity. It simply asks the question, given the data, which hypothesis tested is more likely. For item Q13.1, both hypotheses tested for each individual assumed that Madison Mogen's DNA was present. So when the lab generated a likelihood ratio laid out above, the hypotheses were tested, KG, and one unknown related person versus and 2 unrelated persons. This comparison was done for all of the individuals listed in report number 7 and for Mr. Kohberger in report number 26. At the Idaho State Police Lab, anything greater than 100 is considered a conclusive result indicating inclusion. Any number less than 0.01 is considered a conclusive result indicating exclusion. Thus, if the likelihood ratio falls within the range of 0.01 and 100, the lab cannot draw any conclusion and the data is reported as inconclusive. In her testimony, Miller did not provide a full context of the analysis. The lab reported a series of likelihood ratios for 13.1, including the likelihood ratio of 0.399 for blank, 0.485 for blank, 0.20 for blank, 0.0233 for blank, and lab report 7 at 3. All of these individuals sit in the same shoes as Mr. Kohberger, namely that the likelihood ratio is exclusionary but falls in the range of inconclusive. Of interest is that when the likelihood ratio was calculated for blank and blank, Thus, Mr. Kohberger's inclusive likelihood ratio is similar to almost every other person for whom a likelihood ratio was generated, and focusing on his inconclusive likelihood ratio would mislead the jury. So what they're saying is they think there's some DNA there. They think under their theory that Bryan Kohberger may be there, but it's so small, not a big enough sample, not a big enough statistical analysis that they can actually put Mr. Kohberger there. So something to think about. Another motion, Miss Rowland and her touch DNA contact DNA. Let's just go to the conclusion of this particular document because that's always what they want. As set forth above, the forensic community has come to a consensus that DNA analysts do not have the expertise to render an opinion on how and when DNA samples arrived on an object. In addition to being misleading and inaccurate, allowing such testimony would result in an undue consumption of time. This type of opinion testimony would not satisfy 703 in that the expert cannot be qualified to proffer such an opinion because it falls outside of the expert's specialized knowledge. What do they want to do? It's called a couple of questions on cross-examination. Ma'am, you can't say how that DNA got there. No, I cannot. All I can testify to is that I tested it and it was there. You can't say when it got there. Can you? No, I cannot. There you go. Problem solved. That's what the judge will rule on as well. The bushy eyebrows. The bushy eyebrows. They want the court to grant his motion in limine to exclude DM from using the words bushy eyebrows to identify the intruder that she saw and to exclude DM from identifying Mr. Kohberger based upon bushy eyebrows. Now, this is kind of interesting. Really what it comes down to is there going to be an in-court identification by one of the roommates? Bushy eyebrow facts here. On November 13th, 2022, DM was inside the house when the murder occurred and saw a figure dressed in black, hereinafter the intruder. When she peeked out her bedroom door at 4 a.m., shortly after seeking the intruder, she went downstairs to Bethany Funk's room. The two girls fell asleep. Roughly 8 hours later, a 911 call was made from Bethany's phone at 11:56, motion in limine number 7 to exclude Nunez's narrative. More than 8 hours after seeing the intruder, DM was interviewed by law enforcement at the scene and at the police department. It was confusing to DM that the intruder looked at her but did not come toward her or say anything. When describing the intruder to Officer Nunez at the scene, she described the height, build, and clothing of the intruder. Her description did not mention eyebrows. When she called Bethany before going downstairs to Bethany's room, DM said that she was kind of in and out of it. It was really weird. Later, when she was interviewed at the police department, Detective Mowry inquired about facial features and asked DM if she knew what color the intruder's eyebrows were. She did not know the color of the intruder's eyebrows. Everything was kind of blurry. I don't fully remember. During the Mowry interview, DM again mentioned that she was in and out of it because she was so tired. Then pictures of November 13th. Law enforcement took pictures of DM's room on November 13th and November 19th. On the walls in her room were many pictures of eyes with prominent eyebrows, many of which she had drawn. Some of the eyebrows are heavy, voluminous, puffy, or perhaps subjectively bushy. According to Detective Lake, he found artwork of human figures with an emphasis upon the eyes and eyebrows were pinned to corkboards. Then on November 17th, 4 days later, DM was interviewed by Detective Gooch and indicated that she was really asleep and probably very drunk when she woke up about 4 a.m. on November 13th, 2022. Throughout the interview, DM expressed uncertainty about what she heard and saw and did not know if it was real or if it was a dream in her mind and her mind was playing with her. It just doesn't make sense. She described the intruder and told Detective Gooch that she recalls seeing his eyebrows, his bushy eyebrows, but she did not recall the color of the eyebrows. She did not remember the eyes or the mouth, just the eyebrows. When she saw the intruder, she thought that the intruder was about 3 feet away from her, but that could be off since she was still a little bit drunk. She didn't think that she could remember enough to give a composite artist sketch. She could just recall the bushy eyebrows, but not the shape or the color of them. In an interview, Detective Gooch asked DM if she had anxiety, which led DM stating that she had a lot of lucid dreams about being kidnapped or chased. She indicated that she watched Criminal Minds to fall asleep and crime podcasts. These lucid dreams began in high school. Then on December 1st, A half a month later, DM was interviewed again and described the intruder. She did not see his eyes, but she saw one eyebrow or two, but it was just like the bushy eyebrow. I could just see like an eyebrow, this bushy eyebrow. She did not remember the color or the shape of the eyebrow. She just remembers it being bushy. She did not remember if she saw one eyebrow or two. Throughout the interview, DM indicated that she had always had really bad dreams, lucid dreams, and scary dreams. She did not know what parts of her recollection were dreams and what parts were real. When she woke up the morning of November 13th, she did not fully understand what a dream was a dream or not. In the interview, she indicated she thought that the person had a firearm. Then on December 29th, a statement submitted by law enforcement supporting the arrest warrant used descriptive information for DM's interview. DM described the figure as 5'10" or taller, male, not very muscular, but athletically built, with bushy eyebrows. Then on December 30th, after the arrest of Mr. Kohberger's, DM was interviewed by Detective Lake and Tollison. When she learned that the arrest had been made, she found a mugshot of Bryan Kohberger online. When asked if Mr. Kohberger was the person that she saw in the house, she did not know if Mr. Kohberger was the intruder. She knew that the intruder had looked at her because of the bushy eyebrows. All that she remembered is some bushy eyebrows and all black and some sort of mask. Subsequently, during the grand jury testimony, May 15th of 2023, DM provided grand jury testimony and was questioned about what the intruder was wearing. She was again uncertain, and the testimony is attached but not quoted verbatim. We don't have that because that's grand jury. Anyway, reliability of witness identification. DM peeked out of her bedroom 3 times at 4 a.m. on November 13th. The third time, she saw a figure dressed in black. At the scene, she described the intruder as he was a little bit taller than me, and I couldn't really see much of him, but I'm almost positive he's wearing full black outfit, and he had this mask that was over his forehead and his mouth. And he didn't say anything to me like at all. At the police department, her description of the intruder was similar. And then I opened the door and this guy's right there. And he's maybe like a few inches taller, not like skinny, athletic built. He's all wearing black. He's wearing a mask that covers just his forehead. And there he goes. There were no lights on the stairs. DM was uncertain whether the kitchen light or the bathroom light was on. That might have been a twinkle of light from the living room. Anyway, Morton's, they go on to say all the types of things for cross-examination. Now, she probably will not be allowed to do an in-court identification because she hasn't made one before. It wasn't wrong for her to go look and find the mugshot of Bryan Kohberger. There's no government action whatsoever. The court could allow it, but I don't think they're going to. But it may be one of those aha moments. Do you see the man here in the courtroom that you could describe? And she can say, well, all I could say is he's got the bushy eyebrows. Thank goodness I don't have bushy eyebrows. Anyway, wasn't me. All right. Next, exclude Amazon click activity evidence. This is what we talked about. They're going to bring in evidence about his online activity. Could it be for the purchase of one of these bad boys? Possibly. Motion eliminate improper opinion testimony of Mr. Middleman. He's the Ortham Lab gentleman. We'll see if that comes in. That's already been ruled on, so I don't think it's going to be really relevant at all. And next, a motion eliminate as to the make or model of the suspect vehicle. It states in their motion that pursuant to all the particular rules and the applicable evidence, that this court is required to the extent possible to limit a jury's exposure to inadmissible evidence. The state has claimed in various filings and reports that an FBI forensic examiner, Anthony Immel, identified the make and model of this vehicle seen driving in the area of 1122 King Street in the early morning hours of November 13th of 2022. The state has referred to this as suspect vehicle 1. The vehicle was not identified from surveillance footage in the area at King Road. These photos are from the 1122 King Road camera. Special Agent Immel did not make a vehicle identification and was not made from this footage. Rather, as noted in emails between Mr. Immel and the FBI Special Agent Edward Jacobson, it is clear that the identification of the make and model of the vehicle in this video was made via a separate video taken at 1125 Ridge Road. There's no continuous footage linking this vehicle to 1112 King Road footage and the Ridge Road. Additional surveillance footage depicts vehicles, but not identifying vehicles. Thus, the defense says labeling the car from various bits of footage at the same vehicle is speculative. Mr. Kohberger seeks an order prohibiting the state linking vehicle identification of the make and model of the vehicle in the 1112 King Road video based upon identification of the car at 1125 Ridge Road. The speculative nature of testifying that the vehicle is the same vehicle renders it irrelevant, and these proceedings far more unfairly prejudicial and probative. I believe the individual will be able to say, this is what I did, this is what I see. The jury's going to get to decide. If they say it's the same position, as the defense, I mean, the expert should be allowed to testify as it relates to that particular car, and it'll be up to the jury to decide whether that is the case. All right. I think that's enough for Bryan Kohberger today. I hope you enjoyed it. There's a lot. I'll go through it again as well, and we'll see if we have some more to add. Next, ex-Sheriff Mickey Stein says he was suffering extreme emotional disturbance, aka not guilty, right? Extreme emotional disturbance will be a key portion of the legal defense for the former Kentucky sheriff accused of killing the local judge there in Letcher County in Kentucky. Now, attorney James Bartley, who's representing the former sheriff, Sean Mickey Steins, filed notice with the court last week that the expert evidence relating to mental disease or defect or mental condition bearing on the issue of guilt and punishment will be presented when the case eventually goes to trial. Now, for those who do not know, Steins is killing the district court judge there, Kevin Mullins, back in September of last year. Now, Bartley said he believes there may be more evidence that would support a finding that he wasn't criminally responsible for the shooting. He declined to offer any more information as the case progressed. Now, during a January 17th hearing, Stein's most recent court appearance, a prosecutor said he expected testing and other portions of the discovery process would take about 4 to 6 months. Now, obviously, prior notice has to be given to the state if an attorney is planning to use the evidence of a mental health defense at trial. Now, normally, we're not required to until much later, the attorney for Mr. Stein said, but hey, we don't have a trial date yet, and it's inevitable, so let's just get all this done and see where it leads. Now, Stein has remained in custody since the shooting, which took place inside of Judge Mullins' judge chambers, and they're at the Letcher County Courthouse in downtown Whitesburg. He's pled not guilty to 1 count of murder of a public official, and the case is pending. Now, Mullins has served as a district court judge since 2009. Stein actually served as his bailiff for several years before he was elected, and the two were actually friends. There's been no motive behind the shooting. It's unclear, but during a court hearing last fall, there was footage showing Stein shooting the judge. It appears that Steins had tried to call his daughter just before the shooting and then attempted to call his daughter using the judge's phone. Now, a video from inside Mullins' office taken earlier in the day of the shooting showed that the two men and 3 others talking without any signs of a disagreement or thought that anybody was going to be killed in one way or the other. And Mullins and Steins actually ate lunch together later that afternoon. Now, a date for the case has not yet been set, but we will see what goes on. Next, the solution to the problem does not mean kill the witness. That's right. A Pennsylvania woman allegedly came up with a plan with her boyfriend to kill the police informant who thought helped put him behind bars. And now that woman is behind bars for trying to help out the boyfriend. She's been jailed without bail after allegedly conspiring with her boyfriend from the jail to kill the informant. Amanda Zordman was arrested Monday evening after being charged with conspiracy and solicitation to commit first-degree murder after the state troopers received a letter from an inmate. Zordman had several communications with her boyfriend, Mark Hackett. He's 63, who's currently dealing with numerous drug charges. Hackett and Zordman spoke numerous times in conversations about dealing with the confidential informant and that he believes that got him arrested. He related to Zordman that he had a solution to our problems. Guess what? Those phone recordings, you know, the ones that they always say are being recorded? Well, guess what? They were. And they hatched a plan to give the informant a hot shot of fentanyl, basically an injection of fentanyl to make it look like it was an overdose. Now, Zordman was allegedly in talks with the hitman, and Hackett found in prison and was supposed to help bail him out and take him out to the county and take care of him. And guess what? He was only going to do it for 10 grand. The cost of a hitman has gone down. Anyway, investigators know that Zordman said that she would give the man a pound of meth and cash to bail him out in exchange for his help. Hackett mentioned in conversation with Zordman that once the informant was taken care of, he'd be out of there. Needless to say, the plan fell apart because why? Because the hired hitman always goes to the police to get a better deal for them. Anyway, throughout the investigation and with the information gathered from the troopers, it's believed that Mr. Zortman took substantial steps to try and murder the confidential informant. Like I said, Zortman was jailed March 3rd without bail. A preliminary hearing is scheduled for March 12th. Mark Hackett has also been charged with conspiracy and solicitation for murder. I'm telling you, these are scary, crazy ones. I once had a case where a client wanted the old no face, no case kind of thing, wanted the witness to go away in a very horrible crime, and literally had hired a street gang to go do it. Ultimately, the word got out, and literally the police showed up when the hitmen guys were across the street getting ready to do it. So it is real, it's scary, and it is a possibility. So gotta always be careful. And that is the worst type of crime. Killing witnesses goes against completely everything in our judicial system. Next, the firing squad is going to be used in South Carolina. And it's about time, or at least after 15 years, I would say. So firing squad was originally punishment for mutiny in colonial times, a way of discouraging desertion during the Civil War, and a little dose of some frontier justice, no doubt. Well, in modern times, some consider it a little more humane than lethal injection. Now, the firing squad has a long history in the United States, and specifically, well, South Carolina on Friday is scheduled to put the first person to death by firing squad in the U.S. in 15 years. Certainly a lot less expensive. You can get a couple of bullets for, less than maybe 50 cents a piece. Anyway, Brad Sigmund, who was convicted of killing his ex-girlfriend's parents back in 2001, chose this method over the two other methods in South Carolina, the electric chair and lethal injection. Now, Sigmund, who's 67, chose to die by firing squad because the alternative, well, frankly, seemed a heck of a lot worse. Since 1608, at least 144 civilian prisoners have been executed in America by shooting, nearly all in Utah. Only 3 have occurred since 1977, and when the use of capital punishment resumed after a 10-year pause. The first of those, Gary Gilmore, caused a media sensation in part because he waived his appeal and volunteered to be executed. Now, 5 states, Idaho, Mississippi, Oklahoma, South Carolina, and Utah, authorized the use of a firing squad. So remember, if you ever get in trouble, you got that as an option. Next on the docket, this day in legal history, on March 5th, 1868, the impeachment trial of President Andrew Johnson begins. That's right, the U.S. Senate convened to begin the impeachment trial of President Johnson following his impeachment by the House of Representatives. This was the first impeachment trial of a U.S. president, highlighting the constitutional process and addressing presidential misconduct. On this date in 2004, Martha Stewart was convicted. That's right. Martha Stewart was convicted and charged related to stock trading scandals. It highlighted the issue of insider trading in corporate governments, leading to discussions of business ethics and legal reform. Well, let's be clear. She was investigated for insider trading. She was convicted on making false statements to the FBI in regards to the trading. So had she just kept her mouth shut, she never would have been charged. But hey, Martha Stewart bounced back. She's like 85 years old now, still taking photos by the pool, building her empire. And on this date in 1933, Franklin Delano Roosevelt declares a bank holiday to address the banking crisis during the Great Depression. What did he do? Temporarily closed all banks. This aimed to restore public confidence in the banking system and led to significant financial reforms. And on this date, back in 1984, Lynch v. Donnelly was decided by the United States Supreme Court, and it upheld a nativity scene built on public land by the city of Pawtucket, Rhode Island. The court held that the display did not violate the establishment clause of the First Amendment, which prohibits the government from passing any law respecting the establishment of religion. And on this date in 2010, Larry Langford was sentenced. He was the former Alabama mayor. He was sentenced to 15 years in prison for bribery related to municipal bond swaps. And finally, our dumb criminal of the day. A Texas man posing as a representative of an NBA player stole jewelry worth about $770,000 from a Tiffany & Company store, and he was arrested. And guess what? Obviously, he threw some of the jewelry, but he made some statements. One was in the police car when he said, "I should have just thrown it away." And then at the jail, he asked, "Am I going to be charged for what's in my stomach?" That's right. Jathan Gilder made these statements after being arrested for robbing the jewelry store. He was led back in because the jewelry store people believed that he was a representative of an undisclosed Orlando Magic player. And then he tried to run out of the store. Like I said, made incriminating statements. It's always the defendant's own statements that get them in the end. And like I said, well, they're waiting for some of the evidence to present itself, which will result in further charges as well. So there you go, Mr. Gilder. You are our dumb criminal of the day. All right. I know it was a big show. Hope you enjoyed it. Have a wonderful day. We'll see you next time. And remember, the Constitution matters.